The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to today's panel discussion on privacy challenges for 2020. I'm Christina McLean and I'm Head of Business Development for GRCI Law. I'll be moderating today's session. Thank you very much for joining us for what I'm sure is going to be an interesting and lively discussion. So we will start off by introducing ourselves and the GRC International Group, and then the main discussion will be around 40 minutes long and we'll be exploring some key data privacy challenges and themes, and then we're going to take questions from the audience for about 15 minutes. Just a few housekeeping reminders before we move on to the main event. Delegates will be muted during the session. We have already had quite a lot of questions, but please do submit any other questions and we'll cover as many as we can when we get to the question section. And at the end, the presentation slides and recording will be emailed out to everyone. So, GRCI Law is part of the GRC International Group, and the group is a leading global provider of IT governance, risk management, cybersecurity and data privacy solutions. And we offer a comprehensive range of products and services which are uniquely integrated through our group companies. Some of you will already be familiar with some of the names up here, but obviously they include IT governance, Vigilant Software, IT governance publishing, GRC e-learning, DQM and GRCI Law. So on data privacy alone, group companies have educated more than 10,000 people on the GDPR. We've hosted more than 800 training courses and delivered more than 500 GDPR consultancy projects. So we know a thing or two about data privacy. And GRCI Law is a specialist data protection, privacy, cyber risk and information security, legal and compliance consultancy. So we offer a range of data privacy and data protection solutions, including an outsourced DPO service, data privacy manager, contract and legal, EU representative, data breach and data subject access request services. And our clients are very much a broad church. They range from startups to global organisations, and they operate in a very wide variety of sectors, including health and social care, life sciences, education, professional services, financial institutions, retail, technology, media and telecoms. So here is the agenda for today, and the topics that we'll be covering are key GDPR and privacy compliance issues facing organisations, challenges when handling a DSAR, the DPO role and data transfer requirements in the light of Brexit. Obviously, we've had the Schrems decision earlier today, data breaches and the processes organisations should implement to minimise risk. So I start off by making a few introductions. As I say, I'm Christina McLean and I'm responsible for driving our commercial strategy, client relationship management and new business. And I'm joined by my colleagues John Potts and Rachel McKinney. John, would you like to introduce yourself and tell us a bit about you and what you do at GRCI Law?
Excuse me, good afternoon everybody. As Christina said, I'm John Potts and I'm the head of DPO, DSAR and breach support at GRCI Law, which means that I head up the team that covers all those areas. I've been in the company now for about 20 months, and prior to that I was the head of information law and security, data protection officer and departmental security officer for the Metropolitan Police Service, heavily involved in the PRUM agreement for exchanging of biometric data across the EU. So I've done a lot of work in the EU there. And now, as I say, I head up the teams that look after DSARs and breach. Just as a bit of background, on average, the Metropolitan Police dealt with about 5,500 subject access requests per year and a similar amount of FOI. And I'm not going to say a similar amount of data breaches, but enough to make sure that I got invited to the ISO's Christmas party every year. So,
Rachel, would you like to tell us a bit about you?
Thank you, Christina. Hi everyone, my name's Rachel McKinney and I'm Head of Data Privacy Management here at GRCI Law. I've been with the company for approximately 2 years. I'm a barrister and I've worked both in-house and in private practice, advising on contract disputes and data protection matters. And I head up the team that assists and helps clients who don't require a DPO but need a data privacy manager to help them with their day-to-day data privacy issues.
Thank you both. Okay, so to kick off our discussion today, we thought we would run a short poll on when you last conducted a GDPR compliance audit. So I'm just going to launch that poll now, and if you take a few moments to respond, we should be able to see quite quickly the results coming in. Okay, I'll give you a few moments. Oh, thank you. I'll give it about another 20 seconds or so. Okay, all right, I'm just going to close that poll now and then I'll share the results with you. Just bear with me. Okay, you should be able to see the poll results. John, anything in there that would concern you?
I think so. I'd be concerned about the organisations that have never conducted a GDPR compliance audit in the past couple of years, but I'm unfortunately not surprised by the results. So it is a case of you don't know what's going on. If you've not done a compliance audit, if you don't know where you are, you don't know where your problems and where your gaps are in your compliance, even if you're on the start of that journey of compliance. So yeah, some interesting, quite but not surprising results. Thank you.
Rachel, any thoughts on those results in there?
Yeah, I would echo that, and the fact that I would be concerned about those organisations who haven't actually undertaken an audit. And I would certainly encourage organisations to conduct GDPR audits. I think they're a source of valuable information, certainly a way of measuring and demonstrating compliance with GDPR. It's a way of testing the policies and procedures that are in place to assess whether or not they are being followed and they are actually effective in doing what they're designed to do. And it really goes to that accountability principle. So I would certainly encourage organisations, as I say, to undertake GDPR audits.
Okay, so if we move on to our first question now. What privacy risks should organisations prepare for in 2020? Now, obviously, if you'd have asked that question 6 months ago, it would have been slightly different. We now have the added COVID factor and obviously changes with Brexit and today's ruling. So without further ado, Rachel, do you want to pick up on this one first?
Certainly, surely, yes, as you say, up until a few hours ago, the landscape certainly has changed. And if I can touch on changes in legislation, one of the main changes is going to be in and around Brexit. We will touch on Brexit generally, but I think it's worthy of mention now, particularly in relation to data transfers. And having seen today's decision and the ECG taking the view that Privacy Shield is now an invalid mechanism for data transfers, mainly due to the surveillance laws within the US, model clauses will remain a valid mechanism, but certainly they'll be subject to the view of supervisory authorities who will then to review can actually prohibit or restrict transfers by virtue of model clauses where they think that data protection cannot be ensured in particular third countries. So I think it is very much watch this space for further development, and particular emphasis probably is on Ireland at the moment in view of their involvement obviously being a party to the case. This is likely to impact on the UK's application for adequacy, as UK surveillance laws themselves have been always a bone of contention within Europe, so that is likely to have an impact on the adequacy decision. Just focusing in on supervisory authorities and Brexit. So the ICO will no longer be a supervisory authority under the EU version of GDPR. So it will be interesting to see how the ICO and European supervisory authorities interact going forward, whether there will be a divergence of views, whether there'll be a difference of approach, decisions, enforcement actions, and certainly data transfers, having seen today's decision, might be one of those areas that is subject to further development. The UK government and the EU Commission are currently in discussion about building a framework to facilitate ongoing communication on data protection, but what that looks like and really remains to be seen, and how that will operate, we just don't know at this present moment in time. What we are seeing generally across the board are supervisory authorities, certainly within Europe, with particular emphasis on France and Germany, flexing their muscles. We are seeing more fines in and around Europe, and fully expect that trend to continue. Just talking about and picking up on the current pandemic, there is an increase in processing of special category data, so we're moving out of lockdown. So we will see an increase of special category data being processed, and employers particularly are likely to be capturing more health data. So employers do have a legal duty from a health and safety perspective of their employees and anyone else who might be affected by their business. So they will want to ask they may want to ask employees whether they're exhibiting COVID symptoms, or they may want to introduce testing mechanisms such as thermal screening, whilst possible. Again, before employers actually undertake processing of such data, they've got to be looking at the transparency, fairness and proportionality principles to ensure that they are applied, and DPIAs are undertaken prior to introducing or processing health data. And it's also very important to determine whether or not less intrusive means can be utilised instead of processing special category data, what that might look like. But I think this is something that will be at the forefront of employers' minds for some time to come. We have touched upon health data for COVID, but security of data is also paramount and certainly should be in the forefront of what organisations are thinking about. We have seen an awful lot of people working from home, so the security measures that are adopted should be reviewed and the infrastructure thought about. We've seen a huge increase in phishing attacks and cybersecurity attacks by virtue of individuals working from home. Criminals have obviously caught on to the fact that the infrastructure within the home might not be as robust, perhaps, as might be within an organisation, and they're ready to exploit that, sending emails designed to lure victims to sharing valuable personal data. So it really is imperative that organisations train staff and educate staff, perhaps even staging simulated attacks to see how their staff will actually respond, where the gaps might be identified, and what lessons they can actually learn as a result. And just touching on compliance with policies and procedures, that also homeworking as well brings into compliance with policies and procedures, and that there might be a more relaxed attitude or relaxed approach taken with regards to clear desk policy or destruction storage of data, and it could be that inadvertently information ends up in general waste, or a partner is, for instance, works for a competitor, and it's very much organisations need to ensure that the policies that they have in place and the framework they have in place are actually adhered to, even when their employees are at home.
Thanks, Rachel. John, do you want to just briefly talk about what privacy risks you foresee for the next few months?
Yeah, thanks, Christina. Thanks, Rachel. I think you started off, Christina, by saying if we'd have had this discussion 6 months ago, it would have been totally different. I think we can probably take that back with this announcement from the European Court. We could have taken it back 6 hours and it would have been different. All of a sudden, we're all already thinking about Shamron 2 and the impact that that's going to have on people. I think as we prepare to come out of lockdown, picking up on the points that Rachel was saying, as we prepare to come out of lockdown. But of course, the chances are that for some areas, they're going to go back into lockdown. And as we go into the winter, are we going to go back into full lockdown again? Obviously, that's not what we're discussing here, but we've got to be prepared for that. And I think that's one of the privacy risks that we've got there. We also tend to talk about, when we're talking about home working, about people getting issued with a laptop and working from home on a job issued laptop or whatever. The thing is that I know that there are lots of organisations that were caught out by that and by the home working, so allowed people to bring their own devices to work or effectively use their own computers. The thing is that your customers, your clients expect you to have the same measure of security that you've put out on your privacy notice, what you're going to do, how you're going to secure your data, etc. They expect that no matter where that data is being processed, no matter where they're working from. So it's incumbent on yourselves to make sure that that data is secure in those areas. And that could be something as simple as we've seen with clients, somebody going into the office and forwarding all of John Potts's email to his personal email address. Well, your clients don't expect that, because if you send me something to my personal email address, my wife and my children could actually read it because they've got access to my computer. So they're the things that we've got to pick up on. The health data that Rachel touched on there, without a doubt, as we come out of lockdown, you're going to have to justify what it is that you've done with that personal data, with that Article 9 data. What have you done with it? Where's your DPIA? How is that reflected on your Article 30? What do your staff and your customers know about that data that you've done? So they're the areas that I would say from a practical point of view.
Thank you, John. Obviously some interesting times ahead. So we thought we'd do another poll now and ask you what measures have been put in place to address data security and data breach management. So I'm just going to launch that poll now, and I'll give you a few moments to respond. There we go. There's some interesting numbers coming up at the moment, which I'll share with you in a moment or two. Just a few more people just need to respond. Okay, I'm going to close that now, and I'm going to share the results. So looks like 57% have got a comprehensive incident response management plan. That must hearten you, John, that result.
Sorry.
I said that result must hearten you to see there's 57% have got a comprehensive plan in place.
My apologies, I lost the signal for a moment there. Yes, it does. It always good to see something along those lines. Having a comprehensive incident response management plan in place, do your staff actually know what that means? That's the point that I would make on that. Having the plan, having the policy, has it been explained to them? If one of your home workers turns on their computer, suddenly realizes that they've got the blue screen of death, or they click on a phishing email and realize that they've done that, do they have a separate way of contacting IT? Do they know the phone number of IT, or do they have to then try and get an email to them, which may actually compound the problem that they've already got? So having the incident response management plan in place is great. Making sure it works, that's what I would say you need to look at.
Great. So have you got anything to add to those results?
Yeah, again, I would echo that. I think it's a huge positive that there are response management plans out there, and 57% of participants do have that in place, but it is checking and perhaps going through that simulation to see how it actually performs, because you would want to address any gaps that might be evident in it whilst it's a simulated attack, not when you're actually having to deal with an attack and you're, a breach, and you have the clocks ticking that you potentially have to notify the ICO. So do it when you're not under pressure, you're not stressed, and that would be what I would take out of that, certainly.
Thank you. Okay, so moving on to question 2. Are we seeing a new era of enforcement rather than guidance from supervisory authorities, and what impact is that likely to have? We think there might be a slight change in trend. John, what's your view and your experience?
I think without a doubt we're seeing a shift, and I think there's supervisory authorities across the whole of the member states. Their attitude is shifting on a purely fiscal level. In the quarter 2 this year, across Europe, there were 82,000 euros worth of fines issued. In May, bearing in mind, second anniversary, in May that had gone up to 765.4 thousand, and in June that's in excess of 2.5 million euros worth of fines issued. So I think purely on a fiscal basis, okay, that could be because we're seeing the Act, the fines coming out, and possibly some of those may have been from the 98 Act, sorry, from our own 98 Act, but I think they're all from under GDPR. We're seeing the flexing of the muscles, we'll use that term again if I may, where we've seen the Belgians bucking the trend and saying if you're ahead of anything, you can't be a data protection officer. So that's going out of that sort of bucking the trend there. We're seeing in this past quarter, Spain leading the field with 16 fines over a 3-month period. So they're getting their sort of act together, if I can put it that way. The ICO, without a doubt, has built up her teams. We're seeing more investigations. We're seeing a far quicker response to data breaches, and this is certainly not a knock against the ICO, far from it. I think there are some ICO colleagues on the webinar, or certainly they'll be watching the recording. I know they've now increased their teams. We're reporting data breaches on behalf of clients, and the response that we're getting now from the ICO is much quicker. They've got a slicker organisation there. Their investigation teams are increasing. They're becoming far more specialist. We're seeing the cyber investigation teams. I think we are seeing that shift, and I think from a purely parochial, from an ICO perspective, as opposed to the all statutory authorities, what I think we have to expect is that the ICO, in order to achieve adequacy as we move forward, the ICO has got to be seen to be implementing GDPR set cases, set precedences from across the rest of the member states. So we're certainly seeing that shift there. That's going to improve our adequacy when we come for applying for that. And as you're aware, we can't even start to apply for that until January the 1st. So I think in my summing up, I would say, yes, we are seeing a new era of enforcement. Guidance is still there, don't let's discount that, the guidance is from the ICO is still very, very much to the fore, and I certainly rely on their guidance a great deal, but we are seeing that shift, and I think that shift and that trend has to be expected because of where we're going next.
Thank you, John. Rachel, does that chime with what you're experiencing?
Yes, I would certainly echo John's comments, and I think it is right there. We are seeing an increase in enforcement action, and I do think that will continue going forward and continue to be the norm. And I think for organisations, I think their strategy should be to review their processing activities, ensure that data protection is a primary consideration rather than a secondary consideration, be built into their product, services and design structure and framework structure, document and demonstrate compliance, conduct GDPR audits and test and assess the effectiveness of the measures that they have in place, and it would assist them if they do come under any scrutiny going forward.
Okay, thank you very much. Right, the million-dollar question: how can an organisation become Brexit ready, and what are the key areas of focus? And I think we would all probably benefit from a bit of a crystal ball on this one. Rachel, can you give us your view and get your crystal ball?
Yeah, no, absolutely. I think this is a bit of a crystal ball, particularly in view of today's decision. So we are currently in the transition phase of Brexit, and that won't be extended. In relation to data protection, the UK is being treated as a member state, so in that there is free flow of personal data. So the status quo remains as it is at the moment, but that will come to an end on the 31st of December, and that's when the UK will be classed as third country. So the EU Commission has said that it will consider the UK's adequacy application as soon as possible after withdrawal, with a view to concluding that assessment at the end of the transition period. Whether that's reality, it's not clear. It's not clear when that decision is going to be released. And then again, with today's decision and thinking about surveillance and the surveillance laws, that might be a stumbling block for the UK in actually obtaining adequacy. And so it's not quite clear. But if there is no adequacy decision, then for data transfers, organisations do need to employ an appropriate safeguard. And certainly now they will need to go and review that appropriate safeguard that has been adopted. Are they utilising standard model clauses, or are they utilising Privacy Shield in view of today's decision? And if it's not already done so, the organisation should go back to first principles and actually look at their data flows, understand the data flows, into which countries and jurisdictions data is actually flowing into and out of. Look at the mechanism that's in play. Is it Privacy Shield? Then we'll need to look at something else. As I said earlier, eyes will be on Ireland to see what the next steps are and what they're going to do. We need to understand what view the supervisory authorities are going to take of model clauses, particular jurisdictions. So there is a bit of crystal ball gazing at the moment. It's not clear cut currently at the moment, and certainly what is being utilised most commonly are standard model clauses. I expect that to continue for some time to come, but certainly over the next weeks and months, we will see developments here. So it is very much an area on which to keep focus and understand. But fundamentally, you must understand where your data is actually transferring to. So moving on from that, looking at the one-stop shop. So the one-stop shop and consistency mechanism are still in play at the moment. It still apply to the UK, so the ICO are still the lead authority for organisations operating in the UK. But at the end of the transition periods, come the 31st of December, the ICO will no longer be a supervisory authority as per the EU GDPR. So if the ICO is lead authority, an organisation will need to consider whether there is an alternative authority that they can choose and select as their lead authority within the EU that can serve as their lead authority going forward. if they're no longer in that position to actually benefit from one-stop shop, they will need to consider what supervisory authorities, or it may be one supervisory authority, maybe more than one, not quite sure. They would need to do that analysis to understand which supervisory authority would have jurisdiction over any investigation or complaints, alleged breaches, etc. of GDPR. So really, again, undertaking that data flow mapping, looking at the establishment and where you're operating as a business are key steps to take now in preparation for Brexit. Another and further consideration is the EU representative and the UK representative. Again, look at where your processing activities are taking place, look at where your main establishment is. For those organisations who are not established in the EU currently, and they are monitoring behaviours or providing goods and services to data subjects who are located within the EU, then they should be appointing an EU representative. There are some exemptions in place, so you need to review those to determine whether or not you can benefit from those exemptions. But it's likely that most UK businesses will need to appoint an EU representative come Brexit. In the alternative for EU companies as well, and following the transition period, when UK GDPR comes into force, controllers and processors who are not established in the UK should also be designating a UK representative. We don't have guidance from the ICO as yet as to what that mechanism exactly looks like, but it's fully expected that the UK representative will mirror the roles and responsibilities of an EU rep. So again, I would encourage organisations to look at where their main establishments are and to determine and understand whether or not they should be looking to appoint either a UK representative or an EU representative going forward.
Thank you, Rachel. Well, there's certainly a food for thought on Brexit and what comes next. So the next thing we're going to look at is what key things should organisations do to help deal with the rise in internal DSARs. Now, this is something that we are noticing a lot. There's a spike in internal DSARs and we're getting more and more requests come through for assistance. John, what's your overview of this? What should people do to make sure that they can deal with a DSAR, and what things tend to go horribly wrong?
Thanks, Christina. I think preparation is the key to any DSAR. Knee-jerking when you've got the DSAR, when you've got the complex DSAR, it's probably too late. The downside, there are lots of downsides to COVID, obviously, but as people start to matter furlough, as we start to see redundancies, you know, the jobless figures today are just been released today, are quite frightening. We're going to see DSARs amounting coming out of those. We're already seeing that within with our clients that we're dealing with. So you've got to be prepared for the type of DSAR that you're going to get. And these are internal DSARs. They've now way taken over anything that we see within our clients from customers, which tend to be very easy to deal with. It's the whole internal piece. And what I say to clients is, you don't want to be fighting on two fronts. So if you've had to make somebody redundant and somebody puts in a DSAR, they want to know why they were made redundant and the person who works in the office wasn't made redundant at the same time, or why they've kept their job, they've not had their hours stuck down or anything like that. You've got to be ready for those answers. You've got to do the preparation. Look now towards getting your house in order. Are you retaining data that you shouldn't be retaining? Have you got the right process in place? Do people recognise when they've got a DSAR within the company? As we know, the change in GDPR was that, or one of the changes was that a request for a subject access request doesn't have to be in writing. It can be verbally, it can be on social media. If you're a huge company that uses a lot of social media, who's monitoring your social media? for your subject access request. Think about what's coming next down the line. Don't just think about how you're going to deal with the DSAR. Think about what's the next stage. The ICO is invariably going to get involved. What questions are the ICO going to ask? Again, something that the ICO has done for years is that whenever they receive a complaint from an applicant, they look at it, and the first thing they do is write to the data controller, copying in the applicant. And today's letter says something along the lines of, we've received a complaint from Mr. So-and-so. It would appear that you have failed to answer this in under Article 15 of the GDPR. The applicant also gets a copy of that letter and instantly thinks that the ISO is on their side because they agree that you failed to answer. That's the standard letter. You should be prepared, as I say, for what's coming down there. Don't ignore the DSAR. If you've got a DSAR at the same time as you are receiving an employment tribunal, and again, we're seeing employment tribunals picking up. I'm dealing with a case this morning that is now listed for June next year, and it only went to tribunal a couple of weeks ago, so that's actually quite quickly. You don't want to be fighting the employment tribunal on one hand and then fighting a DSAR with the ICO on the other. You need to make sure you've got that right. Make sure you've got that. Make sure you know the rules around ACAS release if you've got ACAS data. Make sure you know that if you've got a company WhatsApp group, that WhatsApp could be in play for a subject access request. We've seen subject access requests, certainly in the past 6 months, as I say, massively on the rise. We're dealing on at the moment 22 individual records. Now, the chances are that most of those, huge sweeping statement, shouldn't actually be being held. So now's the time to start looking at your retention policies, looking at what you can get rid of. Do it now, not when you receive the DSAR. Emphasize that point, just so nobody quotes me when they're gripping the box, gripping the rail, because as you're probably aware, and if you're not, I'll tell you now, it is a criminal offence. The ICO will prosecute. They prosecuted somebody last month who the company had received a DSAR, and they decided that they were going to shred some of the information that they had before they answered the DSAR. It's a criminal offence. Remember your timeline. Remember that the DSAR clock starts 1 calendar month from the day you receive the DSAR now. So that's where your timeline starts, and that's received within the organisation. Make sure people know who they need to tell about the DSAR. It's getting your preparation done now, making sure you start the timeline, making sure that people know what they're doing, what they're going to answer, and if need be, contact us and we'll help you sort out your DSARs.
Thanks, John. Okay, well, I'm conscious of time, so I'm going to move on to the next poll that we're running. This is what are the main reasons for conducting a DPIA? So I'm just going to launch that one now, and if you could respond fairly quickly, we'll have a quick review of those results when they come in. Fantastic, everybody's voting at the moment, and I can see there's quite a lot of interesting questions coming through as well. Okay, let me just share those results with you. Right, John, thoughts on those results?
Yeah, some good results there. The identify potential compliance gaps at an early stage, ideal. I think it's tempered with the reduce our risk. A DPIA is ostensibly a risk assessment. It's making sure that as part of your change program, anything like that, when anybody comes up with a good idea, The second thing they should think about after that good idea is how does that impact on the privacy of our clients? And that's where your DPIA comes in there. So some interesting results there, the 62% to identify compliance gaps at an early stage, right at the very beginning, and it will impact on all the others as well. So yeah, encouraging in a way.
Rachel, what's your thoughts on that one?
Yeah, definitely encouraging. Again, the only thing that I would comment on is making sure that your change programme and your DPIAs and any changes to processing activities are linked to your Article 30 record or record of processing, to make sure that your Article 30 record's in line with any changes that you might make as an organisation.
Okay, thank you. So that brings us rather nicely on to our next question. How important is it to have appropriate technical and organisational measures in place? What does that actually mean in practice? John?
Perhaps I'll take this one.
Okay.
For me, your appropriate technical and organisational measures are your policies and procedures. So that is really your privacy framework and what builds out and supports and makes up your privacy framework. So from my perspective, technical and organisational measures are imperative, and not only that, it's a requirement of GDPR. So controllers are required to build data protection into their systems, services and products, just as we talked about with the DPIAs, ensuring that data protection and any risks associated are their primary concern. And it's your policies and procedures that are in place that address those such risks and mitigate those risks, and they should be fully embedded into your organisation's operations. And it's having those effective policies and procedures and that firstly assists and helps organisations not only comply with GDPR, but if they're under scrutiny, then that helps them demonstrate how they're complying with GDPR. But they need to be effective. So what does that mean? Then that means that staff need to be given the appropriate training. We need to keep policies and procedures under review, that they're fit for purpose. They're updated where appropriate, where you might be going through a DPIA and updating a processing activity, that all of the corresponding policies and procedures are also updated. Simply having the policy isn't enough, they need to be operational. And again, that maybe takes us full circle to where we were at the beginning and asking about GDPR audits, because a GDPR audit is effectively the tool that you can utilise to see whether or not the policy or procedure is doing what it was designed to do and doing what it was actually, and what is actually written down is effective in practice. So I think testing and assessing your policy procedures are key here. And then asking yourself as an organisation, you know, if a simulation exercise was undertaken, whether it be a breach, phishing attack, DSAR, how would your organisation perform? Would there be gaps identified? And then the lessons learned piece, make sure that you follow up on the lessons learned. What lessons are we actually learning? What should we be doing? What aren't we doing? Or perhaps what are we doing well and need to do more of? So they really are quite key for me here.
John, do you just want to follow up on that?
Yeah, just picking up on the points that Rachel was saying there, and reiterating really that training is the key. Training and understanding your security, your appropriate technical measures. We saw the authorities in Denmark fine a company just this week €6,500 for failing to implement organisational measures on security, where it was a council meeting, in fact, and they put the meeting minutes out. The minutes contained sensitive personal data about adults and near adults, as they were referred to, with no control over who had access to them. So we're seeing those fines coming in. the statutory authorities are not afraid to do that. Your training and your testing is your first line of defence. My area is obviously breaches, as I say, and DSARs. And the first line of defence against the breach is what had you got in place? What had happened? Was it human error? Or was it something that you should have picked up on your DPIA that you hadn't? Your DPIA had fed into your Article 30. Had it been picked up there? Or had you just compounded what was happening at the beginning? So training and understanding is without a doubt the key, I think, to having the appropriate technical and organising measures in place. And I go back to what we said, having the policy is one thing, looking at how it's being implemented and how it's working and do people understand it is perhaps something totally different.
Thanks, John. Definitely some food for thought. So we've had quite a few questions submitted, and I can see there's some more coming in now. So we're going to start to take a few of those questions. The first one is, how can an organisation partly refuse a DSAR where a police investigation is ongoing if they're not subject to the DPA Part 3 and are not a Schedule 7 competent authority? I'm just going to read that one again. How can an organisation partly refuse a DSAR where a police investigation is ongoing if they are not subject to the DPA Part 3 and are not a Schedule 7 competent authority? John, I think this is definitely one for you.
I was hoping you were going to go to Rachel first so that I could get my my head around this one. So thank you. I owe you one, Christina.
Oh, no problem.
This was recognised very, very early on when the Association of Police Chief Officers, Association of Chief Police Officers, which is now the National Police Chiefs Council, first started to look at GDPR in 2016. This is one of the things that started to worry us as to whether organisations would be able to either share data, which is one thing, and withhold data if it was going to impact on the prevention, detection of crime that we were looking at, that was being looked at that time. So representation made to the ICO when the legislation was being built, and the simple answer is yes, you can withhold if you think it's going to prejudice an investigation. Schedule 2 Part 1 gives you that exemption, gives you the right to withhold that information, and also not to have to declare, because as a former DPO of the Met, I can tell you now that sometimes, as we all know, not saying something is as good as saying something. So you wouldn't put on your response, this is what we're releasing to you, but we're not giving you the rest because the police have told us not to. So the exemption is there. So you've got the right to use it. What I would suggest and recommend is that if you've got such a request, you contact the police officer that's dealing with the incident that you're involved in, confirm with them that it might prejudice what they're doing, make a note of that, and then going back to what we're saying about the DSARs, about looking what's coming down the line, when the ICO does come to you and says, we believe you're withholding information, then the ICO, you've got that backing from the police service to tell you why they want it withholding. So simple answer, quite easily, you don't have to be a Schedule 3 body, Schedule 7 body to withhold information under Part 3. I hope that's clear. It's clear in my head. The answer is you can do it.
Thanks, John. Okay, so we're getting quite a lot of COVID health type questions through. It's kind of the same question being asked in a variety of ways. So, what are the data subject's rights when it comes to the organisation disclosing his or her COVID-19 status? What are the data subject's rights when it comes to the organisation disclosing his or her COVID-19 status? Rachel, would you want to pick this one up, please?
Sure. I think what an organisation would need to do, or firstly, their key consideration considerations are transparency, a lawful processing of data, and making sure it's fair. So in order to do that, I think what an organisation would need to do is actually undertake a DPIA before they take any measures. What they would and consider being, and for the transparency point, being clear, open and honest with staff as to how and why they're wanting to use their personal data, how long it's going to be kept for, and who it's going to be shared with. Assess the legal basis of processing. If you're relying on legitimate interests, undertake a legitimate interest assessment. We're talking about special category data, obviously, so our condition is also necessary. So which is the appropriate condition to rely upon, and undertake that assessment and make that decision. Demonstrating that processing is necessary and proportionate, I think, is something that organisations will have to do, and the fact that they will need to justify any decision that they make, they may need to do that at a later date and be able to justify it. So if they take the steps now to assess and understand why they want to do or process data in a particular way, that will put them in better stead if they need to justify that decision at a later point. Also consider, can they actually, is processing of the data actually addressing what they want to do, or is there another way that they can do it without actually having to process this data, you know, and eliminating that risk and actually taking that consideration. So there's lots of factors I think they need to consider before actually going ahead and sharing that information.
John, what are your thoughts on this? Is there anything you want to add, and what should people be thinking about in terms of the next step, perhaps?
I think next steps is as pointed out there, it all starts with those 4 letters again, DPIA. That justification, it's knowing why you are why you're collecting the data in the first instance, what are you going to do with it, your retention policy, all feeds into your DPIA, again into your Article 30. There's a separate line, separate couple of lines for COVID data. That's the thing, that don't just rely on it being normal HR data. The chances are it's not. It's Article 9 data, which you may not process in the normal course of your HR, your recruitment policy, etc. So make sure you've got that. Make sure that feeds in as well to your subject access request. If you've got that data there, make sure that you can answer that in your DSARs. Look towards, if we do have a second lockdown, how are we going to deal with that data there? If you've got an American-based company, how are we going to share that data with the States now? With Privacy Shield and that going, are your model clauses such that you can share that with your main headquarters? So there are lots of things to consider. Be ready for them.
And just to add in there as well, there's lots of guidance that's changing on a daily basis. Keeping up to date on the government guidance and making sure that you understand what the latest government guidance is, I think is also imperative as well.
Thank you both, and thank you to all the people who've submitted COVID-themed health data questions. I hope that was helpful to you. I think we've probably got time for just one more question. I'll read it slowly. We are a small company and our employees are now working from home. Can I monitor employee activity? Rachel, what's your view on that one?
Well, I think, as we've just discussed, I think again we're looking at, you know, undertaking DPIAs, thinking about your what it is that you want to achieve, what information that you want to collect, the reasons for processing. So really, again, DPIA is necessary. Looking at your legal basis and understanding the legal basis for processing, balancing your rights as an employer and are a business owner and your business objective with that of the rights of your employees from a data protection perspective, but also an employment perspective. So you're looking at the situation in the round. And again, it comes back to that justification piece. Can you justify processing that data? And transparency, I think, is also key, particularly when we're talking about monitoring. Being transparent with employees, understanding and being open with what it is you're looking to do, what information you would be seeking to monitor, why you would be seeking to monitor, and how long you're keeping it, thinking about retention periods, undertaking that legitimate interest assessment if that's the legal basis on which you are actually going to rely. So yeah, I think there are lots of associated risks. So again, we're looking at transparency, fairness of processing and legality.
Thank you. John, do you want the final word on this one?
Yeah, I think just quickly, I would say that if you've got the right policies and procedures in place within the office, then homework is an extension of that. So if you've got policies that talk about use of systems for using the internet, surfing the web during lunchtime and everything else, those policies should be updated to say this also reflects at home working up there. So again, it's that take it right back to basics. We don't need to knee-jerk that this is happening now because we need the policies in place to begin with. And then all the other things that Rachel said, and bear in mind, of course, that you may also have a health and safety attitude towards working from home as well. So it's not just all about data protection, data privacy.
Thank you. Well, I'm afraid that we are very fast running out of time. Thank you so much to all of you who have submitted questions, and I'm sorry we couldn't get to any more of them. I'd just like to quickly remind you that we offer a full suite of data privacy services and solutions, and I'd like to take the opportunity on behalf of GRCI Law to thank you for joining us for our session today and for inputting and for submitting your questions. Just a quick reminder, we will be emailing the recording out and along with the slides, and if you need any assistance or you want to know more about us, you can find out more by visiting our website, our group websites, and you can follow us on LinkedIn, Facebook and Twitter, or you can pick up the phone or email us, and we're very glad to hear from you. So thank you very much for your time today.